And right out of the gate, this case is a bombshell. Michelle Cormier is facing a first-degree murder charge tied to fentanyl. That's not just drugs. That's life and death, with the law treating fentanyl delivery as lethal as pulling a trigger.
You are Michelle Lee Cormier, and Ms. Cormier is charged with the first-degree felony offense of murder in cause number 25 DCCR 0153. Mr. Radford has filed there's a motion to quash the indictment. The state has filed a reply, and obviously I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder.
Judge, if I may, the common law has established murder is when someone intentionally, knowingly caused.
Okay, but the statute is what we're discussing.
Yes, ma'am. Right. I don't think it was the intention of the legislature to remove the records mens rea.
What makes you think that?
Because common law going back 1,000 years has required murder to be intentionally knowingly.
But they've added section B4, which is a little...
Here's where it gets tricky. The defense is fighting over mens rea, the legal state of mind. Do prosecutors have to prove Cormier intended to cause death, or just that she knowingly delivered fentanyl? That one-word difference could mean the difference between technical guilt and reasonable doubt.
Confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers controlled substance included in penalty group 1B, blah, blah, blah. No, that's what the allegation is. So it actually has the mens rea of knowingly deliver. It reads straight from the statute, so I'm going to deny that motion.
Yeah.
Sure.
Yeah. Under this indictment, the way where the doctor gives patient fentanyl, the patient dies, and the doctor is charged with murder, even with his non-intention knowing.
Well, there's an exception. The next C, except as provided, it is a defense to the prosecution under section B4, which is our section that the actor's conduct in manufacturing or delivering was authorized under 481 Health and Safety Code of State of Federal Law, which I think would be the medical process.
So
there's
this is my understanding in court of the opinion that the state must prove my client knowingly delivered fentanyl.
That's what the law says, and that's what the indictment says. It's then and there knowingly deliver controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingesting and inhaling into her body. So
the opinion of the court, Ms. Cormier must have the records knowledge that she was doing fentanyl.
I think that's... Go ahead. I'm gonna lie. Well, I think that's going to be another whole question because it's specific that it
says knowingly
deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I'm not going to make that decision. That's not that's just an element of the offense. So the motion to quash.
And there it is. The judge shuts the door. No loopholes, no wiggle room. If Cormier knowingly handed off fentanyl and it led to a death, that alone is enough to carry a murder conviction to trial. The weight just got a whole lot heavier.
I'm not going to find it. I'm going to follow it as written. Alright, so that's denied. Mr. Radford has also filed a motion to reduce the bond. Do you plan on calling your client, ma'am, the best you can? Raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
For the purposes of this hearing only, we call Michelle Cormier on this bond reduction.
Just so you know, what she's under, I mean, I don't let anybody go far. She's under oath, and I am allowed to take into consideration underlying fact of the case. We won't go far, but just don't want you to think that we're not. You go there at all.
Shelby. And you are continuing to dispense, sir? Yeah. And your bond currently stated $500,000. If you afford $500,000, do you have assets and things that you make family can help you? Have you talked to the family about possibly helping you? And how much, what kind of bond you can come up? $100,000. Would it assist your case and presentation of defense if you were bonded out and assist me in working on it? Where were you born? And have you lived here? How long? Did you pretty much live here your whole life? Yes. Do you have family in Missouri? Yes. Where would you live if you lived on? Where would you live?
Did you catch that? The allegation isn't some back alley deal. It says she smuggled drugs inside jail, passed them along, and another inmate died from fentanyl. That's not just a violation, that's a scandal inside a locked facility.
Fortunate conditions of your bond, including GPS monitor, and drug check. What is your criminal history? Secret there?
I do my whole parole. Yeah, yes, I don't know. I think it's probably in this reply. What was Miss Cormier in custody for when this happened? Okay. So the allegations here are that you were in custody for theft. In custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death and had some. Not correct. All right, go ahead, Mr. Coleman.
Allegations are what this drug female is buying her into.
Thank you.
While you were in design, kill something, see. Again, judging going to check. That is not relevant. I'll move on.
Thank you.
What did you object this time?
No. I think any of those are going to go to her Fifth Amendment right against self-incrimination.
Arrested on down topic 2024. You have pending felony drug case in Louisiana. Has been written for 60 what happened.
Yes, sir. Status of that case.
I don't think it's in trial.
They're waiting on drug testing. Okay. Anything else?
No, ma'am.
All right. Based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a heat and bond. I think $500,000 is adequate based on the nature of all of those matters. All right. Anything else then on this?
No, ma'am.
Okay, we'll reset it for an announcement.
Ma'am,
Yeah, thank you.
Judge, for the announcement purposes, I'm waiting on a report from my extra branches.
Okay, we'll just do a normal reset. We'll be at that point. Thank you.
And here's the kicker. She wasn't just accused in this case. She already had a pending meth possession charge. So the judge isn't just looking at one bad decision, but a pattern. What do you think? Should prior cases tip the scales, or should each stand alone?
You can go back with the bailiff. All right, so are you Howard Celestine? And Ms. Prazo, will your client waive a formal reading of the indictment in each case? Mr. Celestine, in cause number 24, DCCR 0919, you're charged with a third-degree felony offense of manufacturing or delivering a controlled substance from January 10th of 2024. That indictment alleges that you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? And is that prior offense, that prior conviction, the one that I read out, the aggravated sexual assault of a child, is that true that that is a prior conviction of yours? Clause number 24, DCCR 1549, says count one only, but then it says a 20-year term, so it has to be count 1 and 2. If it's 20, count 1 and 2. Okay. There's only one crime.
Right.
So that's what makes that third degree turn into a second. So pleading on count 1 would only be to the underlying offense.
Right.
Okay, so in 24 DCCR 1549, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from June 24th of 2024. The indictment alleges that same prior conviction, April 13th of 2009. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And again, is that prior conviction true? And did you enter your plea of guilty in this case freely and voluntarily? And because you actually did what they've charged you with. So in cause number 24 DCCR 1550, you're charged with a first-degree felony offense of murder from June 24th of 2024. The state's elected to proceed on that count only. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with. In cause number 24 DCCR 1551, you're charged in that case with a state jail felony offense of abandoning or endangering a child from June 24th of 2024. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with. In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Ross? Do you fully understand? And do you understand if I follow the agreements that you've reached with the district attorney, you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization?
And with that, the gavel drops on her bond hopes. $500,000. Way out of reach for most families. Bottom line, Lee Cormier will be fighting this murder charge from behind bars, and the road ahead looks brutal.
Federal law. State tenders number 1 in each case. It's admitted in each case. Is there any evidence, Mr. Celestine?
No.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true in the cases that you did freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas in each case. In cause number 24 DCCR 0919, find sufficient evidence to find you guilty, and at this time find you guilty of manufacturing or delivering a controlled substance. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody. The law gives you the right to receive. In cause number 24 DCCR 1549, also find that you entered your plea of guilty freely and voluntarily. finds sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon, find that prior conviction true, sentence you in accordance with your agreement to term of 50 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 1550, find sufficient evidence to find you guilty, and at this time find that you entered freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder, sentence you in accordance with your agreement to a term of 50 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 1551, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I am making an affirmative finding of a deadly weapon in cause number 24, DCCR 1549. I'm handing you in all of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws to make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to us. All right. Good luck to you, sir. You can go back with the bailiff.